New at 6, the Alabama Attorney General's office is now taking over the prosecution of Timothy Vess Benton. That case, Benton, who was sentenced to 17 years after pleading guilty to 2 counts of sodomy, was transferred into Fayette Community Corrections after serving just over 5.5 years of his sentence. Now, weeks after being transferred, Benton was arrested on a sex offender registration violation and released on bond. The I-Team's Valerie Bell was first on this story and continues to stay on top of all developments.
New court documents filed Wednesday show Assistant Attorneys General Lee Wathney and Matthew Kimbrough will serve as the counsel for the state in Timothy Vess Benton's case. AG Steve Marshall says they will push for Benton to serve the remainder of his sentence in state prison.
That's the position the local DA took, and that's the position we'll take in the hearing.
What do you plan to do moving forward to ensure that victims and their families are part of this process?
Yeah, 2 things. Number 1 is that we'll make sure that all parties involved are notified of what's pending. In this case, it's 2 separate motions in the original action. One to modify the judge's original order placing the defendant on community corrections, but the more important one is the fact that by violating with the new SORNA violation, the conditions for which he was placed in community corrections, will be asking that he be put back into prison.
As the I-Team first reported, one victim's father, Christopher Key, among community members, not satisfied with Benton being transferred to community corrections. Marshall says until their motion is heard, Benton remains on house arrest.
My understanding was that the Baldwin County authorities have determined that in fact that home is not eligible for him to be based on the location of something that would violate the SORNA provisions. So he would be simply subject to the electronic monitoring that the court had ordered. But again, we're going to ask that that be removed.
Key also expressed frustration that they found out about Benton's transfer on Facebook weeks after. Marshall says that never should have happened. We're
new to this case and not aware of why at least one of the victims' families would not have been notified. And I think we need to be able to answer that question. But broadly, we've been very strong advocates for victims' rights in our state, including the issue of notification, particularly when it would involve the modification of a sentence. Here, this family fully believed that the defendant was in the custody of the Department of Corrections, had every reason to believe that, and then for suddenly them to learn that that had been changed, that's not the way the system should work, and we'll try to figure out the reasons why that happened.
And that was Valerie Bell reporting. The preliminary hearing previously set for September 15th was removed from the docket. Marshall says now his office is waiting for a date where a judge will hear their revocation motion, where his office requests Benton be placed back in prison based on the new charge.